Welcome back, everyone. Today's courtroom drama kicks off with not one, but two explosive disputes and, trust me, both are filled with legal twists, misunderstandings, and plenty of drama. First up, we've got Dale Gretsch versus Taylor Adams, where the issue boils down to garnishments basically when money is pulled directly from someone's paycheck or account to satisfy a debt. Right away, things heat up because the defense doesn't even bother showing up. And if you've ever wondered what happens when you skip court, this case shows you the brutal reality. The court almost never looks kindly on a no-show. But the real meat of today's video, that's the next case, Jim Mayan versus Fatima Stevenson. Here, we're diving deep into a tangled mess of real estate confusion, where both sides are pointing fingers, and even realtors seem to be making the situation worse. Was Fatima genuinely trying to buy the property she lived in, or was this just a clever delay tactic to avoid eviction? And bigger question, what happens when miscommunication creates apparent authority for someone who may not even be authorized? This case has it all: property law, contract law, and the raw human stakes of potentially losing your home. Stick around, because the judge's ruling at the end is not what anyone expected.
Court does call the case of Dale Gretsch versus Taylor Adams.
Good morning, Your Honor. Alex Barry Santoro appearing on behalf of Plaintiff Dale Gretsch and Dina Davis, P81545. Nice to see you.
Good seeing you, sir. And this is, I thought, defendant's objections to garnishment?
That's accurate, Your Honor. I did file a writ of garnishment, and there was an objection served after the 14 deadline to effectively stay the garnishment. So I'm here today to
object to any stay of the garnishment. Right?
Yeah, that's the lawyer.
I'm brilliant. I figured that all out on my own.
Yeah.
And they're not here. Taylor Adams, Tiffany Gross.
You want me to call the hall or something?
Well, Adams, Gross, the defendant having failed to appear. The motion regarding the objections to the garnishment are denied. Garnishment may proceed. That denial is based not only on the defendant's failure to appear, but also on the merits of their objections.
Thank you, Your Honor. I appreciate your time.
Thank you, sir. Jim versus Fatima Stevenson.
Fatima Stevenson appearing on behalf of herself. Good morning.
Good morning, Your Honor. Jay McCurgy on behalf of Jingmei Shin, P8321.
All right. And this is your motion for relief from judgment, ma'am?
That is correct.
All right. What do you want to tell me about it?
Counsel and I originally in late May, I believe, were discussing the option of me purchasing the home that I'm currently renting, because at that time I was made aware that the owner was intending to sell the home. So it would have benefited all parties if we were able to make this transaction occur. It has taken a little bit of time. We've all kind of, well, I can't say.
And there, it is with justice. Notice how the judge doesn't hesitate for even a second to deny the objections to garnishment. Why? Because the defendants simply didn't show up. In court, timing and presence matter. You missed deadlines. You skip hearings. Well, the law doesn't wait for you. Garnishment can devastate someone financially, but once the judge sees both a late filing and a failure to appear, it's game over. What do you think? Should the court always rule this harshly when someone doesn't show up, or should judges give more second chances?
We've all, but counsel and I have corresponded through email, as you've seen. The property manager, who is also a realtor, and I and the realtor I had secured recently have also been in communications as of yesterday. I was just made aware late yesterday afternoon that the property manager, who was in correspondence with my realtor and lender, is not the listing agent. So therefore had no authorization this entire time to work on the deal. And so anyway, long story short, I had not looked for alternate living. I wasn't intending to seek alternate arrangements to move out, because my intention was to actually purchase the property. It wasn't going to be a quick thing, but it was going to take a little time. But as long as I showed progress and all the relevant parties that were interested were kind of kept in the loop to showcase good faith that we could move forward with that and stay the eviction.
Response.
Thank you, Your Honor. The home is not currently for sale. Hasn't been listed yet. My client wants to get the property back.
But, okay, just so that I'm clear, the original his conditional order of dismissal
Correct.
was put into place with contemplation of a sale?
That's correct.
No, Your Honor. That is not. Stevenson is representing that we've been in discussion for sale of that home. That is not accurate.
Okay, but was there somebody let me ask this. Whether they had authorization or not, was there somebody operating on plaintiff's behalf that was leading toward a sale?
So there was after the affidavit was sent in late June, Ms. Stevenson sent me this email that she has, I guess, attached to this motion here, that she's been approved for a mortgage.
Okay.
And as you can follow through this email chain here, essentially, she wanted to put together an offer, and I said, if you're going to do that, you might want to do it quick because we're running out of time here. And that's essentially where that conversation ended on my part.
Right, but there were also other individuals that
The
were.
text messages, Your Honor?
Yeah, well, there are other individuals that are involved that are seeming to indicate that the purchase.
On the plaintiff's side, Your Honor, there is a realtor who's the property manager who had asked Ms. Stevenson for a pre-approval letter or something at some point. Nothing was provided. I have an email chain here that I can submit for the record. Let's call it and it clarifies what happened.
Clarifies. Well, okay, so here's what I'm getting at. There's someone on the plaintiff's side that is talking to somebody on the defendant's side regarding the sale. I'm a bit concerned because as I'm hearing you, the person on the plaintiff's side is a realtor, right?
That's correct.
There are, it seems to me, discussions that are going on regarding, between.
Here's where things get complicated and, honestly, heartbreaking. Stevenson explains she didn't look for alternative housing because she believed she was on track to buy the property she lived in. Think about that for a second. From her perspective, she was working toward ownership, not facing eviction. But the entire deal hinged on miscommunication with people who might not have even had the authority to negotiate a sale. Imagine planning your future, lining up a mortgage, only to find out that the person you've been dealing with wasn't even officially connected. That's not just confusion, it's chaos. Audience, put yourself in her shoes. Would you have trusted those emails, or would you have looked for a backup plan?
The person that's a realtor on the plaintiff's side and a realtor on the defendant's side.
So the person who's a realtor on the plaintiff's side has no agreement to sell the home. There's no.
I get the fact that there may not be some agreement between plaintiff and this person.
Okay, in no way does this person represent the plaintiff or their interests.
In some way they do, don't they?
So, Your Honor, I think the statement that this person is the property manager is incorrect because this person has told me they're not the property manager of the property.
Who are they then?
They
vis-a-vis the property.
They helped the homeowner purchase this home or find this home as a property for their portfolio.
Say that again?
They helped the homeowner find the home as a property for their portfolio, as an investment property. This property.
Okay. Okay.
Yeah.
If that's all they are, why are they entering into discussion?
Your Honor, I don't know. If we look through, I have an email from that person in an email chain that both Ms. Stevenson and I were included on from yesterday, and it describes an email between her realtor and this other person describing what.
This other person being whom?
The person's name is Kurt Glassel.
And that's the person that now you're saying is nothing regarding this property.
That's correct, Your Honor.
Then why are they involved in an email chain?
This email, so Ms. Stevenson, I would say, was speaking to a realtor. This realtor reached out to this person they believed to be the real estate agent for this property, although that wasn't the case. And they had a discussion of this email that both Ms. Stevenson and I were.
Close up and no, go ahead.
Yeah, this email that we were both a party to clarifies what that discussion was and that they, what they believe the intent of that discussion was.
If I could clarify one thing, Your Honor. In the email from counsel, it clearly states in the email that I had submitted with a motion for the recommendation was for me to send the offer letter to this individual.
Now this is courtroom drama at its finest. The judge is visibly frustrated. Who exactly is this so-called property manager? One side says he's involved, the other says he has no authority, yet his name keeps popping up in crucial emails. This is a classic example of what lawyers call apparent authority, when someone appears to have the right to act, even if legally they don't. In the danger, if a tenant reasonably believes this person represents the landlord, their actions could legally bind the landlord. It's a gray area, and courts hate gray. But tell me, do you think Fatima genuinely got misled here, or was she just reaching for any lifeline to stall the eviction?
In particular, and then
This person who now is being claimed to be nothing.
Yep, exactly. That's.
I do have other.
Well, okay, hold on, folks. This may make sense to you, it doesn't make sense to me. Why would she be sending an offer letter to somebody who really has no affiliation to the property?
Oh, I was thinking he would communicate that offer to the home. Should there have been an offer? Because I'm not.
Then, right, but is, okay, Mr. McCurdy, that's part of my problem. Part of my problem is this person and your client may be saying they have nothing to do with the property. Apparently, the defendant believes they do and is operating with some apparent authority. And you yourself also may not know what that position is, but like you said, I'm not a realtor, but this person is doing something. And the very fact that the person is a realtor, I think that there certainly is the potential for some confusion regarding that. And I think that's part of my.
I do have more recent communication as of yesterday with the same person.
With who?
With that same realtor, and my realtor and the lender.
And the lender?
So, if Your Honor, if I
Go
may
ahead.
clarify, I have an email right here between all parties just clarifying what has happened in an email. And the email includes her realtor, this email chain includes an email from her realtor, back and forth. I believe it's relevant.
This part is fascinating from a legal perspective. The judge is basically saying, look, even if there was no official listing, the involvement of realtors and a lender creates the appearance of a pending sale. That's huge, because even without a signed contract, conversations, emails, and loan pre-approvals can build the impression that a legitimate transaction was underway. And when those impressions influence someone's housing decisions, like not finding another place to live, the court takes that seriously. Here's the million-dollar question. Should intent and communication weigh as heavily as an actual signed agreement? Or should the law stick strictly to, if it's not in writing, it doesn't exist?
Okay, but Mr. McCurdy, the very fact that all of this needs to be clarified, isn't that a problem?
So, Your Honor, after I spoke to Ms. Stevenson yesterday, she made it clear that she was gonna believe that she's been misled here. So I reached out to the realtor to see what was going on.
Right.
If she hadn't been misled, if there was discussions with the loan officer, if there was discussions with a fellow realtor. And what he described to me was something close to what we're talking about here, but not but missing the target by a little bit. He believes this was a last minute attempt to confuse the situation and stay the eviction. And he clarified that in an email because the realtor who reached out to him had not signed an agreement with Ms. Stevenson. It was just an informal discussion about what if that property were to be for sale. Now, he clarifies in the email that I have in front of me that he doesn't know where these numbers are coming from and that he...
What numbers? The offer?
Yeah, correct, Your Honor. Because no discussion had ever occurred about what that listing price would be. No discussion occurred about a wire transfer.
Okay, all right, but counsel, something's going on. I have two realtors on opposite sides, regardless of what their authority is. All right, I have two realtors, and then at some point, according to the defendant in this case, there are communications with a lender. That
The
go ahead.
realtor the realtor who's standing on the plaintiff's side I don't believe had any communications with the lender for Ms. Stevens.
Is that right or no?
I have email here with Kirk Glassel in communication, several phone calls, or a few phone calls, I should say several, with my realtor, and she was relaying information between him to the lender. And there's including the good faith deposit, the amount of that, including something about a back rent that and all of these other components that would,
Okay. Okay, that's my concern. It may very well be, Mr. McCurdy, that your client gave no authority for this person to act in this fashion. But what's clear based upon the representations of the court is that they were. And I don't know.
Ms. Stevens has been putting forth since the conditional dismissal that she was wanting to purchase this home.
Mm-hmm.
After the affidavit went in with the order, I received this email saying, I've been approved for a mortgage. I'm going to try and put together an offer for this home. If any of those things are true, I don't know, Connor. Beyond that, no communications until the writ was posted to the door. And then all of a sudden this started as of last Thursday or Friday. If Ms. Stevenson would like additional time, we're happy to accommodate her. We can make any arrangements she finds like reasonable, but I don't believe the writ should be overturned.
The problem that I see here is that there's something else that's going on, which, as the defendant has stated, led her to do or not do things. Plaintiff may have a different version that she's coming up at the last minute, doing whatever. Regardless of all of that, I have two realtors. I all of a sudden have a lender involved. I would just say that if Miss Stevenson has gone to those extremes just to delay, it's a lot. I don't think that that's what she did. I don't think the communications that I've seen and the ones that are being described are that. Something, rightly or wrongly, it seems to me, was represented to her regarding the sale of this property. Okay.
Property was never listed. That's
right, but I don't.
okay.
I hear you, but if you had from the plaintiff's side, your everyday run-of-the-mill property manager, not a realtor. They're just managing your property, make sure that repairs are done, collect whatever. Okay. And she's having discussions with that person. Then I might tend to agree that there's not enough there doing anything. This is different because this person's a realtor. And by the way, I don't think somebody goes up when somebody's a realtor and say, do you have the listing? I mean, I don't know that comes out of anybody's mouth right out of the gate, unless it's the realtor that says that to somebody. You assume that they have the ability to sort of move in the way that they're moving, right? So I get it, but something transpired here that either Miss Stevenson was misled potentially, or something occurred where she just didn't understand it and how the transaction was going to go, or something. I think for your client, Mr. McCurdy, I don't know if she knows what the heck has transpired, because somebody is apparently, well, I'm not making this conclusion, but at least from Ms. Stevenson's perspective, somebody is acting on her behalf or their behalf. And
This is the emotional heart of the case. The judge lays it out. Either Stevenson was deliberately misled or she simply misunderstood the process. And both possibilities matter, because at the end of the day, we're talking about someone's home. You can feel the judge balancing the cold letter of the law. No written contract, no deal, against the human element of someone potentially being strung along. It's a powerful reminder that courtrooms aren't just about rules. In statutes, they're about lives. Would you side with strict legal technicalities here, or give her the benefit of the doubt?
it's just, it seems to me, doing things and making things that may be representations that have to stick to your client. But I don't know. Now, having said that, other problem, Ms. Stevenson, that you have is typically any agreement regarding the sale of property would need to be in writing, right? But so there may not have been an agreement, and that may be this court's ultimate conclusion. But I also realize that there are discussions that happen before there's any writing that's put into place. I mean, just in a practical sense. So from what I've seen today, I think it would be improper and imprudent on this court's part to issue to allow the writ to be executed. So at this juncture, the court is going to stay the order of eviction of the writ in this case. I'm going to order an evidentiary hearing on the issue regarding a sale. I will set that for August 11th, and I apologize for pushing it out to that point, but my docket is what my docket is, folks. And I'm going to try to take a vacation, or at least not be here. So August 11th, 2025, I will set that at 2 p.m. Okay, there's a criminal evidentiary hearing ahead of you, and I've got to take care of the criminal matter. But in the interim, I might suggest that the parties try to talk to get straight exactly what's transpiring on the plaintiff's side and what may have been said. Ms. Stevenson, you also, and one of the things that you said this morning is that you hadn't had time to make alternative arrangements regarding yourself. So I might suggest that you at least have a plan B, because I don't know what I'm going to rule on this. All right?
I agree.
All right. Thank you, folks.
Thank you, Your Honor.
Thank you.
And there's the bombshell ruling. Instead of allowing the eviction to move forward, the judge hits pause and calls for an evidentiary hearing. Translation: the court wants a deeper dive into whether a real deal was ever on the table. That means more witnesses, more documents, and possibly more drama. For Stevenson, this is a lifeline, a chance to prove she wasn't just stalling, but genuinely trying to buy her home. For the landlord, it's a frustrating delay in reclaiming the property. Big picture, this case shows how easily miscommunication can snowball into legal battles, especially when realtors, lenders, and tenants all have different understandings of the same situation. If you found this breakdown as shocking and eye-opening as we did, make sure to hit that like button. Drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.